Be ready, start. Mr. Sanjay Jain, learned senior counsel, was appointed as amicus curiae to assist the court on behalf of the appellant, whereas Miss Neelam Grover, learned advocate, appeared on behalf of the CBI respondent stop. Learned senior counsel has also filed his written submissions, which have been carefully gone through by me stop. I have also gone through the entire record of the trial court as well as the impugned judgment with utmost care stop stanza. The learned senior counsel for the appellant had argued that there are fundamental and other errors in the impugned judgment stop. He had referred to the testimony of the witnesses on record, and by reference to the same, he had argued that there was absolutely no evidence of demand or acceptance of illegal gratification by the appellant, and in the absence of such evidence, the court below had committed an error in shifting the onus of proof to explain the charges slapped on him stop. The evidence pointed out by the learned counsel and the contentions raised thereon during the course of arguments shall be dealt with at appropriate places hereinafter stop. On the other hand, Miss Neelam Grover, learned advocate for the CBI respondent, had argued in support of the reasonings for conviction contained in the impugned judgment stop. She had submitted that though the independent witnesses have turned hostile, but their testimony, to the extent they have supported the prosecution by their admission of various acts, may be looked into as corroborative evidence of support the testimony of the complainant (PW1) and that of the trap laying officer (PW9) stop. She also relied upon the conduct of the appellant of his running away on seeing the raid party, and this, according to her, proves the guilt of the appellant of accepting the illegal gratification from the relatives of deceased stop. Rima Miss Grover relied upon a judgment of the Supreme Court in support of her contentions that conviction can be based only on the statement of trap laying officer DeHorse, other evidence on record stop. I have given my annexes thought to the revile arguments advanced by the learned counsel for the parties stop. All cases of corruption have two important aspects, and they are first, demand, and second, acceptance stop. Unless demand and acceptance of illegal gratification but by the public servant charged with under the Prevention of Corruption Act are proved by the prosecution beyond doubt, the presumption provided for in section 20 of the Act cannot be drawn stop.